Wright versus State of New York.
Jeffrey Lang for the state. I'd like to reserve 2 minutes for rebuttal. 2 minutes.
Yes.
When the legislature passed the Child Victims Act in 2019, it revived certain claims alleging the sexual abuse of minors, a small subset of which have been brought against the state in the Court of Claims. But while the legislature amended the Claims Act to allow claimants to bring what would otherwise be time-barred claims, it didn't amend the pleading standards in Claims Act 11B.
So, counsel, what else might have been included that would have put it over the line, in your opinion?
Well, I think for the problem stems from the lack of allegations regarding the nature of the claim and the time when. So for the nature of the claim, a brief explanation of how the state was negligent in non-conclusory terms. So the real problem here has to do with the very conclusory allegations regarding the state's notice.
And if they had named a person, would that have been sufficient?
I think we'd want more than that. We would want an explanation for how the state either knew or should have known that this abuse was going on in the egg. So they only give two reasons, for the state's notice. One, they say that claimant says that the abuse was open and obvious, but it occurred in places like bathroom stalls, the boiler room, stairwells, tunnels, theater.
Do you think a name was absolutely necessary, or could you do a legally sufficient pleading not knowing the name of the individual?
I think if you didn't know the name, but they identified the abusers in some other way.
So for example, if the pleading had alleged, I participated in a specific after-school activity and the coach sexually abused me, would that be sufficient?
You would need to know why the state was negligent for failing to prevent that abuse. So that would be the only additional piece beyond what you said. The state could not be negligent for the coach's abuse, assuming the coach was a state employee, because it's well settled that sexual abuse is outside the scope of employment.
What if they said something like, and the state was aware because it was common knowledge that the person was a pedophile?
Well, you would want to know how it was common knowledge. And they allege something like that here. Oh. So they say that these were child predators that were, whose reputation as such was well known in the community.
Would you need to allege how the state would know that these particular individuals, or that they're sufficiently identified, albeit even without a name, such that the state could investigate?
I think you would want to know something about their identity, and also something about why the state was on notice or should have been on notice.
So are you arguing by the manner in which they describe them here, it could be anybody at any time, and how could you even figure out why the state could be liable or would be liable, because you have no idea who these people are?
That is exactly what we're arguing. The court in the Heisler case that was cited by this court in Lepkowski, which is the main precedent in this area, said that there's not a requirement of absolute exactness. And we agree with that. But it also said that allegations that are conclusory or say that the state was negligent in a very general sense are insufficient. And that's
what do we do about the challenges of recalling details with the lapse of time, and the goal of the CVA to allow for a revival of causes of action that's meaningful? It seems like we have to grapple with that, right?
Yes, and I think that all the changes in the pleading standards or proof standards, those have always come from the legislature. So, and a very important point here.
I appreciate that, but and I take your point that, Section 10 is amended and Section 11 has not been amended, but it may be, I take it, that under those pleading standards, that given the lapse of time, it could be very difficult for someone to plead with the requisite specificity that you would expect in a different kind of case. And so what are we to make of that, given that the legislature clearly had some intention to allow for revival of claims against the state since it amended 10B?
Well, if the pleading standards were such that it presented an insuperable barrier, then I agree that there would be a problem and you would have to reconcile the two. But here, we're simply not asking for the level of detail that might prove an insuperable barrier. And in fact, we give examples. There are plenty of claims.
Yeah, tell us about you say there are claims that have proceeded.
Yes.
Right, and are there claims that have proceeded from a similar time frame as this one that are decades previous?
Yes, many, in fact. I mean, there were...
What does many mean, like 3 or 20
No,
or
more than that.
50?
I mean, I can give you some sense of the
just order
numbers,
of
and I don't have
magnitude.
them precise. I mean,
I
many of these
understand.
are a decade old, but there were something like 300 claims brought against the state, something like 10,000 overall, but 300 against the state. There are still 150 that remain open. These are approximate numbers. So out of that 300, the state moved to dismiss 880 based on a pleading flaw, either the time when, the nature of the claim, or in some instances, the place where. Place where is not an issue here. And at the trial court level in the Court of Claims, roughly half of them those motions were granted, so.
But in half they were denied, I take it
And
then.
half they were denied, and then a number of those where they were denied. So there were approximately 44 out of the 80 where we moved to dismiss, 44 were granted, and then there were roughly like 14 or 15 of those that were reversed on appeal, especially following the Fenton and Meyer cases. And many of those claims are decades old, and claimants have alleged a sufficient amount of information.
Can I just ask you, assume for a second that we agree with the proposition that this lack of amendment on the pleading statute creates an impossible or an undue burden for a certain class of people to allege their claims with sufficient specificity. What are the legal options available to a court like this, short of saying, well, that's what the legislature did? How can we remedy that situation?
I think you can't. I think what the court should say is these are the standards that the legislature put in place, and in Kolnacki is instructive. There, the claimant had argued there was a requirement at the time that claimants in personal injury and medical malpractice cases had to allege the total amount of damages up front. And the claimant argued that's very difficult for claimants to do at the beginning of the case. And in Kolnacki, this court said, well, that's the requirement that's in the statute. And the result may be harsh, but it's really for the legislature to reconsider if that requirement poses too much of a barrier to claimants.
So if this,
And that's
if this was not an action against the state, would this have survived traditional liberal pleading standards requirements as we have articulated them?
I believe this claim is so conclusory that even if it had not been against the state, it would not have survived the normal standards for pleading negligence claims in New York, which is you're required to plead
Are you asking us to come up with a per se rule on either time or on the nature of the complaints, or are you saying just the nature of these claims?
What we're asking is for the court to follow Lipkowski and the pre-CVA appellate division cases. There were many precedents in this area, and they all said, and I gave the example of the Heisler decision earlier, so that's the right standard, which is absolute exactness is not required, but a basic explanation for, in non-conclusory terms, of how the state was negligent for the nature of the claim. And then if I can also move to the time when, because we have an argument that the time when here.
What is the minimum you would want on time when?
So for the time when, if you're only alleging a discrete number of acts, then the time when should be specified. It doesn't necessarily need to be a specific date, but it should be a very narrow range.
What's
And
very narrow?
I would say, weeks, and here we just have nothing. I mean, what they allege.
So, for example, I was in the summer program for 8 weeks in the summer of 1992. Is that and that's when this
And
happened?
that would probably be sufficient, and I was the victim of abuse a number of times in that
8-week period.
In that 8-week period, and that would probably be
But he
sufficient.
does allege he was abused. I believe the words that the claim uses is repeatedly, right?
Yes.
And so if the allegation in more detail would be between 1986 and 1990 and set to the side the nature, which I think would probably be more likely to involve allegations about what brought him to the egg in the first place, right? But if he was there on a weekly basis and was alleging that he was repeatedly abused while there in some capacity, is it your view that he would have to say, weeks 1 and 3, but not week 2? What is it exactly that's not specific, given that he does use the word repeatedly?
Well, so if he said, I was there virtually every week of the year, so we don't, all he says is repeated and multiple. Was this a summer program? And we don't know the hours. Was he there? We don't even know why he was at the Egg. I mean, the Egg isn't a residence. It's a performing arts center. Was he there for performances? Was he there as part of some type of student program? We just don't know anything.
So is the time when then impacted by the nature of the claim? So in other words, if he said, I took acting courses for 4 years at the Egg, and this is what happened, would that be sufficient? Or is the time when that period is too long for you?
Well, he would have to say, I took acting classes for 4 years, and when were they? You would want to know a bit more details about when they were.
Yeah, if they give you the 4-year period, and during that time I was abused.
Multiple
In other
times
words,
a week.
do we look at the time when and the nature of the circumstances siloed, or do they really impact and inform each other?
I think they are relatively siloed, and that's because in Lipkowski, this court said that the state shouldn't have to ferret out and assemble information that the claimant is required to allege. So even if we could reconstruct the time based on some information, it needs to be alleged.
But weren't the circumstances, well, let me step back. My understanding is that the purpose of the requirement is to enable the state to ascertain its liability with a fair amount of certainty, right? And so I thought in Lepkowski, I thought those were FLISA overtime claims, and so you needed to know exactly what the dates were, exactly, so that you could actually go and look at the records for that particular day, because either you worked overtime on day X or you did not, right? Is such precision required with a claim like this?
So I don't think it is. Not that level of precision, but we just don't, but certainly more than what is alleged. I'll give you, an example. In the Robin B.B. case that the Third Department decided in 2013, the allegation was numerous acts of, it was a sexual abuse, this is a pre-CVA case, of sexual abuse by a state trooper over an 8-year period. And that's simply not enough. I mean, the state shouldn't have to investigate over a multi-year period. So you need a narrower date range. And the reason that it's important is for exactly the reasons that Justice Cheryl Chambers in her Rodriguez concurrence said, which is that the pleading standards reflect a balance between allowing claims to go forward against the state's interest in limiting its liability, limiting its litigation expenses. And it's even favorable to claimants in the sense that if there's enough information in a claim, that allows a prompt investigation and the state can promptly settle meritorious claims.
If we reverse, can the plaintiff replead?
No, because he's outside the window and you can't correct a jurisdictional defect in the Court of Claims. Thank you.
May it please the court, Seth Diamond on behalf of the claimant respondent, Mr. Wright. I'm here with my colleague, Michael McCready's. I wanted to just begin with the line of questioning that Justice Halligan was asking my friend about the distinction in the type of claims, because I think this is an important foundational point about claims in general, which is there's a wide variety of claims that can be asserted against the state. And you cannot take a one-size-fits-all approach into evaluating whether any type of claim or specific claim satisfies.
Do the pleading requirements required of the Court of Claims Act apply to these types of cases?
I would submit that they do, because section.
And how did the pleadings here satisfy those requirements?
Well, the standard to be employed is that set forth by this court in Lepkowski, which is the guiding principle, which asks, is there sufficient definiteness for the state to be able to begin its investigation?
So what about that? I mean, if you were the state, what steps specifically would you take in an effort to ascertain the liability here? Who would you go to? What records would you look at?
So let me preface that answer with one point, which is the type of claim alleged here casts a very wide net as far as the conduct that's involved. We're not alleging that just Mr. Wright was abused. We're alleging multiple boys were abused. We're not alleging there's one perpetrator. We're alleging multiple perpetrators occurring on the premises in an open and obvious manner right under the state's nose.
So how would you proceed specifically?
I think the way to start the investigation is to go to anyone that worked there during this period in time and ask them, were you aware of this activity occurring? Did you hear rumors about this activity?
How do you
Wait a minute,
identify?
anyone?
Anyone.
That could be thousands and thousands of people?
Well, that's at least the starting point, and you could
But
focus
how do
particularly.
you focus on which employees to speak to?
Well, based on the allegations, we've alleged this occurring in the audience of the theater related to the Institute for Performing Arts.
Do you indicate specifically the time frame? So
Yes.
that one could identify the employees, winter,
Yes,
fall?
1986. This is paragraphs
So
4 and
you go
paragraph
through
7.
anybody who worked there, period.
Well-
What I'm trying to ascertain is what in your pleadings allows the state to properly investigate?
So the first thing is where it occurred, because we're alleging it occurred in the theater, in the bathrooms, in the boiler room, in the tunnels.
So
we are.
is your view that you'd have to interview some number of employees? What if they went and looked at the employment records from 86 to 90 and they identified 10 people and interviewed them? Would that be sufficient? What are the metes and bounds of the investigation that you think would be required?
I think it would be sufficient if any of them said, oh yeah, I heard about this happening. That
What if
would be
none of them? What if
confirmed.
you went to 10 and they said, didn't hear anything, don't know what you're talking about? Would that be enough?
Well, that would be enough for their investigation. And I think based on where this occurred, they could focus on particular types of employees, janitorial staff.
Yeah, but that's not really
those-
fair, right? Because where it occurred, the where could be Madison Square Garden, or the where could be the Egg, or the where could be an after-school program at St. Bartholomew. I mean, there's different wheres that would, the context of which would enable the state to defend itself. Without names and without a more streamlined where, it seems that you're asking a lot of the state, because I don't know practically where they begin this investigation.
Well, Mr. Wright cannot provide names because of the nature of the conduct. This was.
So let me ask you this, is this the most information that you know? There's not another bit of information you know?
Well, at the time this claim was
Right,
filed.
at the time it was
which
filed.
was almost 4 years ago.
Understand.
This is the extent of the information that he knew because of the psychological trauma associated with this type of horrific acts
So he
against
didn't know
children.
why he was at the Egg?
Well, he identifies in the claim that he was lawfully present, and this is open to
One
the
would
public.
hope, but he doesn't explain why?
Why?
It's not explained in the claim.
Don't you agree that why he was present would help narrow the scope of people that may have been involved in the conduct that he alleges?
I think that it could help, but
Which
that's not.
days of the
but
week,
that-
which days of the week he was there? What times of the day he was there? He presumably knew those things?
Well, that could have been alleged, and it could help, but that's not the standard of whether there's sufficient definiteness to allow them to begin the
here's what I'm-
investigation.
But there were also allegations that the public was involved. How would they investigate that?
But that goes back to the idea that this is ubiquitous, rampant activity occurring on the premises, that this is not involving just one
But
person.
again, how would they investigate that?
Well, that is what I was suggesting, that if they look to people involved with the Institute for Performing Arts, which is SUNY, and we've alleged that this is associated with teachers, counselors, and coaches
From
who are
where?
involved.
Where are the teachers, counselors, and coaches from?
That's associated with the Institute for Performing Arts. Paragraph 3
But
of
is
the
the
claim.
Institute for Performing Arts its own freestanding? These are teachers and coaches and counselors that only worked for the Institute, or did they work for a school in conjunction?
Well, if you're drawing reasonable inferences from the claim, which is required, then the inference to draw is that they're associated with the SUNY Institute operating out of the egg. And,
Associated is quite a broad term.
but that's at least a place to start, to say, let's go find the employees who were in the capacity of teachers, coaches, and counselors associated with the SUNY Institute during the timeframe of 1986 to
You raise a
1990.
good point, it seems to me, about the challenges of recollecting specifics given the lapse of time. But it also seems that the legislature could have, if it chose to, have amended the pleading standards. And I think it did that with respect to Section 8, for example, which governs unjust convictions. And that suggests, to me anyway, that when the legislature wants to alter the pleading standards because it may be particularly difficult for a claimant to allege with the kind of specificity that Section 11 requires, that it knows how to do that. But instead, I think it just amended Section 10. So what do we make of that?
I have two responses to that, Justice Halligan. The first is they did it for unjust conviction, and there's no quantum of specificity as to the standard to be employed in Section 11B, which means they left it up to the courts.
But our cases, I think, shed some light on what that means, and it may be that you can meet that, but it may be that the complaint as it sits doesn't meet that.
Well, there's a second element to this, which is when we look at the statutes and we try to harmonize the statutes, the CVA explicitly incorporates any crime within Penal Law 130 as constituting a factual predicate for a CVA claim. So if you look at Penal Law 130.75, that is the continuing crime statute. And what this court has said in People v. Pabon in 2016 regarding the interpretation of that statute is it is predicated on repeated sexual abuses of a child over an extended period of time, explicitly because those children are unable to identify or recall specific dates and what occurred on any specific date.
I'm not sure how that amends Section 11 or alters what Section 11 would require.
It doesn't amend Section 11. What it does is provide the predicate for the CVA claim, and in harmonizing the two statutes, this court should, I submit, take into consideration as part of the circumstances the fact that this is a continuing crime that fits neatly within
That
statute.
statement brings me back to where you started when you got up, which was this assertion that the level of specificity required is somehow dependent on the type of claim that is being made. And I'm just wondering what your support for that argument is. Is it the language that you're referring to in the CVA right now, or do you have some other authority that would instruct us on that?
Judge Canatara, it's predicated on a review of the case law. And let me give you three very quick examples to show you how disparate the type of claim is, which leads to a distinction in how Section 11B is analyzed for those claims. One of the cases brought up was Lepkowski, which is overtime worked but not compensated for. So if the state's trying to determine that, they need to know, are we talking about 100 hours or are we talking about 100,000 hours? But that analysis is entirely distinct than, for example, the toxic torts exposure in the Fourth Department's decision.
But to stay on Lepkowski for a moment, the nature of the claim there was highly specified, right? I think it said identified the bargaining unit, which is fairly specific, the specific civil service title, grade that the person had. That's much more, it seems to me, than what you have here. In other words, if much more from this perspective, if I was trying to investigate, which is what the cases say, the purpose of the pleading specificity is intended to serve, I would have a pretty good idea of exactly where to go, wouldn't I?
For the nature of, that's true. But the
Yes.
time when and the place where, and that was deficient.
Yes, but staying on the nature of, because I think you probably need to show both, right? You need to show
Correct.
sufficient specificity with both. How are the allegations here akin to those in Lepkowski with respect to the specificity of the nature of?
Well, I think part of it is we have to look at what the causes of action are that are alleged. So one of them is the premise liability cause of action, which is our third cause of action. And so we've identified all the elements in a non-conclusory way. The state's duty to supervise the premises and duty of ordinary care associated with the premises. We've alleged notice in the sense that these activities were open and obvious, that it was pervasive in the sense that other boys were being abused at the same time, and that in paragraph 66 of the claim, that the state knew that this had been occurring on the premises previously and did nothing to stop it moving forward.
What's the source of the knowledge?
Well, that, Judge Rivera, goes to the evidentiary support. And that is something this court has said.
Well, that goes to whether the allegations are conclusory, no?
Well, the allegations need to make out the claims of the cause of action. And if they are addressing specific things, like here we're alleging breach in the failure to monitor and supervise the specific areas, bathrooms and audience of the theater. So that's not a conclusory assertion. It's directed specifically to the facts of this case. But my friend raised the issue of how. And I think how is something that goes more towards the evidentiary underpinnings of the claim, which is not required to be in a claim. And that's something that may come to light later on.
So you don't think it's a fair question to ask when you're having a debate over the sufficiency of the pleadings to say, when you allege failure to monitor bathrooms, how do you mean, are you talking about having security guards in bathrooms, or, I mean, what, is there something inherently unfair about inquiring about the nature of the claim to see whether it's been alleged specifically enough?
No, there's nothing inherently unfair about it, but the ultimate question is whether there's sufficient definiteness to allow them to begin the investigation. That's the guiding principle of Lepkowski. And I think that is a circumstance-based approach.
But here's the thing, let's just stick with this one description. If it's a claim that something happened in a bathroom over the course of some 4-year period, I would think to even begin an investigation, you have to ask, well, who was it that was supposed to be in the bathroom? Because if you say a security guard, then you can go to the security department and say, you know, what was going on in the bathrooms between 1996 and 2000, or 86 and 90, whatever it was. But none of that's here. None of that's in this pleading.
We do allege that in paragraph 99 on page 28 of the record, which is the failure to have proper security on the premises to monitor what was occurring. And this is operating as a private enterprise, so they have the same duty that a landowner does to members of the public to prevent foreseeable criminal activity occurring on the premises. And so these...
But paragraph 99 is very broad. It seems to me, you know, it says that there are employees of the state of New York, OGS, and SUNY. That sweeps pretty broadly, right?
And it does because of the nature of the conduct alleged, which is widespread activity occurring on the premises. If Mr. Wright is there being repeatedly abused during this four-year period of time, and he doesn't know or cannot identify these people except by indicia.
That seems quite reasonable and logical. But to the extent that he knows why he's present, knows whether or not it's the weekend or the weekday, that would go a long way to assist the state with its investigation.
I think,
And to say whether or not, as I asked you before, the counselor, I'm trying to remember, counselor, coach, teachers were employed specifically by the institute or were employees somewhere else, even if the claimant doesn't have their names. Again, that would go a very long way to assist the state. But without that, it does seem that it's almost an impossible task.
well, I agree that it would, the more specificity, obviously, the better everyone would
Well, I'm
be.
not talking about more as in more, even more helpful. I'm talking about the bare minimum so that they can do the type of investigation that the statute contemplates and that we contemplate in our prior case law.
Well, the information provided in the claim is the extent that Mr. Wright is able to recount at 4 years ago when he filed the claim, based on the conduct that occurred 40
So
years ago.
4 years ago, he didn't know why he was there or what days of the week he was there. 4 years ago, he didn't know that.
Well, yeah, I can't speak directly to whether he knew it or not, Your Honor, but I can tell you that
You just did, I think. You just told us that that was all he could say is what's in the complaint.
Well, he alleged that he was lawfully present there.
No, but
And from a.
Does he know why he was there? Did he know at the time?
He might
why
now.
was
I'm not sure if he knew at the
4
time.
years ago, did he know? You don't know whether he knew 4 years ago?
I don't, Your Honor.
Okay.
There's also a claim in the complaint about that the abusers were failed to be removed. Is that a suggestion that there was complaints made and the failure to act, so that there was knowledge on behalf of one of these entities?
Yes.
That there was an abuser there?
Yes, and we do allege that they were retained in the employment as teachers, coaches, and counselors, and we allege that there were prior complaints of sexual molestation related to the premises at the Egg. Thank you.
So can we pick it up from that point? So if there were allegations that there was abuse that was known, why is that so difficult for the state to then investigate?
Well, because that was the extent of the allegation, just that the abuse was open and obvious and that the abusers were known as child predators.
Well, there is
Those
a
are the only-
negligent retention claim, right?
Yes, but for negligent retention,
Couldn't
an
you go look
element-
at whether there were complaints filed during the years?
There's nothing in the claim that anyone reported this abuse to any state employee.
I know, I'm not sure that's responsive to the question, though. Could you go and look and see if there were complaints filed regarding sexual abuse or inappropriate touching or anything along those lines during the 4-year period with regard to activities at the Egg?
Well, I mean, complaints filed with who? I mean, I'm not sure. There were 3 agencies that are alleged to be involved. The claim doesn't say what role each agency had. One of those agencies, the Empire State Institute for the Performing Arts, hasn't existed in 20 years. So, sure, there are investigatory steps that could be taken. I'm not saying an investigation is impossible, but it would be extraordinarily difficult given the lack of information in the claim. And just, 2 quick points. They only allege that one, look at R21 in the record, they only allege that one of the abusers was a teacher, coach, or counselor. And he doesn't say whether that person was a state employee or not. It's paragraph 63 and paragraph 73. Otherwise, none of the abusers are named. None of the state employees who were allegedly negligent were named. And just one brief point on monitoring the bathrooms. I mean, the only reason to have security in the bathrooms would have been if you already had knowledge that there was improper activity going on in the bathrooms. But there's no allegation, again, in non-conclusory terms as to why the state had or should have had such knowledge, making an investigation of the claim extraordinarily difficult.
Thank you.
Thank you.